Here we go. Let's see. Fucking hell. The court's requirement of a close historical comparator has turned out to be almost impossible to satisfy. Good. Shall not be infringed. Shall not be infringed. Shall not be infringed. It's not fucking ambiguous, you dumb cuck. It's almost impossible to satisfy. Almost. It should be impossible. The language says shall not be infringed. The way the court reads the language is shall not be infringed unless it meets our stringent test. But that's not what it says. It was intended to never meet a court stringent test. And the court was fucking cucks. And Congress was bullshit. They didn't tamp this shit down back then. So now we're stuck with the courts making constitutional law when they never had the power. And if you want my rant on Marbury versus Madison, I've given it several fucking times. But everybody who disagrees with me on Marbury versus Madison is fucking wrong, because the Constitution does not contemplate constitutional review and binding precedent on this shit. It does not contemplate that they could effectively rewrite the Second Amendment. These motherfuckers struggled over that Second Amendment. It's evident in the language of the text, the bad syntax, the shitty grammar, the fucked up punctuation of a well-regulated militia being necessary to a free state. The right of the people to keep and bear arms shall not be infringed. That doesn't make sense. No one talks like that now. No one talked like that in 1790 either. However, that's a compromise over days and days and days of hot, sweaty men arguing over what that fucking thing should say. And what it ultimately says is well-regulated militias are essential to keeping a free society. Bam. Period. Done. That's it. That's a thought. The next thought is the right of the people who may, on occasion, randomly be conscripted into service of the general militia to keep and bear arms that they would bring to the militia, but also that they would use to defend themselves, and most importantly, that they would use to defend themselves from tyranny, shall not be infringed. It wasn't a fucking mystery, because everybody had a gun. You had to have a gun. You had to kill your own food. You had to kill your own British. You had to kill your own detractors. Everything was fucking murder-based in 1790. The death sentence was the sentence for felonies. There were only like 6. We took crime way differently. We took reputation way differently. And we took fucking tyranny way differently. It's not ambiguous. It's not weird. It's not a mystery. It's not hard to figure out. When they said the right of the people to keep and bear arms shall not be infringed, they literally meant don't fucking touch the guns, the swords, the knives, the fisticuffs, anything. Don't touch it. And they didn't. There were not laws restricting these ownerships. You could own a cannon. You could own a boat full of fucking cannons, and you could park it outside of Plymouth. All the cannons, enough cannons to lay siege to a port city. And they said, of course you can own that. Because freedom, baby, personal responsibility, individual pride, and accountability for your actions, not your thoughts, not your words, not your impressions, not someone else's interpretation. Your actions were either criminal or not. Period. And fuck all these people. Fuck everybody who defends Marbury versus Madison. Fuck everybody who defends every incremental restriction on absolute liberty shall not be infringed is in the Second Amendment. the First Amendment. No law respecting the establishment of religion, the right of the people to speak, the freedom of the press, freedom of assembly, freedom of religion. No law. And yet we have hundreds of laws on that topic, hundreds of laws on guns. Those should have been constitutional amendments. The founders believed that the Constitution would be rewritten in 30 years. They believed that the amendment process would handle all of these weird discrepancies. They were wrong because the courts took the power that is not granted to them in Article 3 of the Constitution of constitutional review. They took extra constitutional powers to tell other branches they weren't being constitutional. And we let them. Starting all the way back at the Madison decision, we let them do this. Well, 1803, something like that. What is Marbury? Yeah, 1803, Marbury versus Madison. God damn, sometimes my drunk brain is a fucking encyclopedia. Holy shit. All right. Rant mode off.
Click the like and subscribe button. It's the best subscribe button, biggest best button.